Good evening. Thank you for joining us. My name is Rob Bronner. I'm the Executive Director for the Atlanta Beltline Partnership, and we are the nonprofit entity that supports the vision for the Atlanta Beltline. And that vision includes the creation and the preservation of mixed income communities. One of the ways that we do this is through our home empowerment workshops, like this one tonight. And while we definitely believe that the Beltline brings a lot of positive health and economic and transportation benefits to the neighborhoods it connects, we also know that both renters and homeowners can feel that they're being pushed out due to rising housing costs. And we understand that these financial pressures may be felt more severely now than ever due to the negative economic impacts of the COVID-19 pandemic. And we want you to be able to feel secure in your home. And we want you to be able to remain in your neighborhood, in your community. And we're grateful that funding from Wells Fargo and Bank of America have enabled us to provide these workshops throughout the year to connect Beltline residents with the partners and the resources to help you stay in your home. My one request of you this evening is that if you find this workshop to be helpful, please tell your neighbors and anyone else who you think could benefit from this information to help us get the word out. We are recording this. This will be available online, and we need your help if you find it useful in helping others learn about this important information. I'm also very grateful that we are joined this evening by Terry Lee. Terry is the Chief Housing Officer for the City of Atlanta, and her leadership and her partnership have been absolutely instrumental in advancing Mayor Bottom's One Atlanta Housing Affordability Action Plan. And I can say she has challenged us at the Beltline in very positive ways to make sure that the Beltline is truly for everyone. You'll hear from Terry in just a few minutes, but first I want to introduce our program manager, Jen Tremen, who will give an overview of tonight's workshop.
Great. Thank you, Rob, for that introduction, and good evening, everyone. I'm glad that you were able to join us tonight. And like Rob said, if you find this information useful, please share the recording and the supplemental documents that we will be emailing out tomorrow morning. In addition to Terry Lee, I want to introduce tonight's presenters. We have Darius Woods with Atlanta Volunteer Lawyers Foundation, Lindsay Siegel with Atlanta Legal Aid, and Sarah Kelsey also with Atlanta Legal Aid. Some of the topics they'll cover tonight are existing protections for tenants in the state of Georgia, as well as the eviction process. We'll also learn more about some added protections for both renters and homeowners under the Federal CARES Act, as well as different places and resources you can go to find help during this troubling time. Just some housekeeping rules really quickly. Please keep yourselves on mute for the entirety of the workshop. If you have a question, please submit it in the chat feature, and we'll do our very best to answer all of the questions. If you submitted a question ahead of time, we will also cover those throughout the presentation. If you find yourself at the end of the session having more questions or needing help with your individual circumstance, we'd be happy to connect you to the presenters or for other information after the session. And without further ado, I would like to turn it over to Terry to say a few welcoming remarks on behalf of the City of Atlanta. If you can go ahead and unmute yourself and take it away.
Absolutely. Thank you, Jan. Good evening. I first want to just thank you all for joining us this evening and definitely welcome you to this conversation. But I would be remiss if I just didn't take a moment to just recognize that many of us are coming to this workshop this afternoon with a lot of anxiety, some frustrations, and definitely some unknowns. And it is my sincere prayer that each of you and your families are remaining safe during this time period and are really getting the assistance and the help that we all need right now. This is a challenging time. We're learning a new normal every day. And I think that is something that we all have to recognize, which is really why it's important that we're having this conversation tonight. Since March 13th, I think the entire world has turned upside down, and the world has turned upside down in a city that already had an affordability crisis. I've had the opportunity to serve and been blessed to serve as your chief housing officer for about a year and a half now. And I will tell you that Mayor Bottoms is strongly committed to ensuring that Atlanta becomes a city that anyone who desires to live here can call home. And that still stands true today. While we've seen a lot of changes over the last couple of months, I believe Atlanta is committed to be stronger than we've ever been before. And one of the things that we've actually launched as a city is an Atlanta Strong campaign. and the Atlanta Strong campaign is really geared towards providing information as well as resources to our residents during these trying times. If you have not, I encourage you to look at the city's Atlanta Strong website. There's a lot of consumer information, much of the information you're here tonight, but definitely some frequently asked questions that can help you as we really just kind of tread through the next several months that we have before us. There are a lot of things, again, on the city's website. In addition to just COVID-19 itself, we have resources about where you and your loved ones can get tested, additional resources for small business owners, as well as mental health and food resources if needed. Our team is continuing to work to make sure that information is up to date and is as current as it possibly can be in order to be able to provide the best resources to our residents. I would also be remiss if I didn't thank Legalaid, the Atlanta Volunteer Lawyers Foundation, as well as Wells Fargo for leading this effort tonight. Again, your partnership to the City of Atlanta is one that we are just very proud to have, and the collaborative efforts are really, really great, and they help our residents to provide information to our residents that's much needed. I also want to thank Rob for his leadership with the Atlanta Beltline Partnership. The Atlanta Beltline is a world-renowned project, but what I would tell you is that we have very strong homegrown love through Rob and his leadership, and he is really committed to making sure that we have equity along the Beltline. And he's committed to make sure conversations like these actually occur, where we can make sure we bring the resources to our residents. In addition to the information you'll have tonight, I really want to leave 3 key numbers with you. If you have any questions in regards to where you can get assistance, financial assistance for rental, mortgage, and/or the payment of your utilities, please call 211. The 211 system is sponsored through United Way. If you have any questions related to City of Atlanta, COVID-19, or Atlanta Strong website, please call 311. And if by any chance, and I'm sure you'll hear this from Legalaid and the Volunteer Lawyers Foundation, if by any chance you're being faced with an illegal eviction, please call 911. We released a social media campaign on last week to make sure that our residents and our tenants know their rights and know that they can't be forced to leave their homes. Again, I'm looking forward to learning more alongside this team tonight. I'm grateful for the opportunity to be with you, and my prayers are with each one of you as we journey through this time. Jen, I'll turn it back over to you.
Thank you, Terry, for those words, and definitely are grateful for our partners for their time today. And we will share the Atlanta Strong website in our follow-up email, and we'll repeat those numbers for people to call as well, so they have that handy. And at this time, I will pass it over to Darius, I believe, to start his presentation to talk more about the eviction process in Georgia.
Yes. Hey, everyone. My name is Darius Woods. I'm an attorney at the Atlanta Volunteer Lawyers Foundation. I work with our Standing with Our Neighbors program, and we're based out of the West Side neighborhoods. So all the way from Campbellton Road up to Donnelly Hollowell. That is kind of my zone. I want to thank everybody, all of our partners, the Atlanta Beltline Partnership, Legalaid, the City of Atlanta, for helping to organize this and putting this together. We really appreciate it because we know this information is important for you all. And I want to thank everybody for taking their time at 6 o'clock to be here on this virtual call. We really appreciate it. And as Jim mentioned, feel free to share this presentation with anyone you think will benefit. I'm going to try to share my screen here. Bear with me. Let's see. Okay, so I think I'm sharing my screen. And basically what we're going to be talking about today is housing protections during COVID-19. I'm going to start off by talking about what is currently available. And thank you, Terry, for mentioning you definitely want to call 911 if your landlord is attempting to evict you without going through the dispossessory process. So everything I'm about to talk about now is just what is currently available, what we know is available to you at this point. And I'm also going to go over some details about the eviction process. So there are certain grounds for evictions, and they may be extending to what's available here. The main cause for eviction is the failure to pay. And I think that's what a lot of people are probably dealing with right now, because COVID-19 has created an unprecedented crisis that a lot of people just can't pay their rent. You can see I start the failure to pay because failure to pay, even because of COVID-19, isn't a defense to an eviction, to a dispossessory. And I know that might sound, kind of ridiculous, but at this time, for the majority of people who are renting, failure to pay is not a defense. And I know Lindsay is going to get into more detail where that could be a potential defense under the Federal CARES Act and under the City of Atlanta's moratorium. But as of right now, it is not a defense. So when you're answering your dispossessory, you can't just say, hey, COVID-19, I lost my job and I can't pay. Another ground for eviction is holding over beyond the lease of beyond the term of the lease. So I know a lot of people probably were thinking about moving around March or April, but they couldn't move because COVID-19 was occurring. That's the grounds for eviction when the court reopens, and there are not really any defenses for holding over beyond the term of the lease, but there may be some exceptions that may apply, and you'll need to talk with an attorney to see if you qualify for one of those exceptions. And if it's a tenancy at will or a tenancy at sufferance, and those are month-to-month leases and people who are holding over beyond the term of their lease, and we call that a tenant at sufferance. And if it's a violation of lease terms and conditions, so many leases have like community rules, and if you violate those community rules, that may be a cause for eviction or ground for eviction. So when we're going through the eviction process, step one is the demand for possession. And we also call that the notice to vacate. So this letter must be sent before the landlord can even file a dispossessory. And most of this is going to be focused on dispossessories that were already filed between March 14th and today. So you should have, if you have an eviction, if you know someone who has an eviction filed against them, they should have received a demand for possession first. And it specifies a specific amount of days before the landlord will start the dispossessory process by filing the dispossessory warrant. So after that is after the notice was to vacate is given to the tenant, and if they fail to pay their outstanding rent in full, that gives the landlord the authority to file for a dispossessory affidavit. And here's a picture of what the dispossessory affidavit looks like. It's pretty simple, and for the most part, when I see dispossessory affidavits, it's usually for failure to pay rent past due. And it's going to have some information about the landlord, and you should also have your case number. Now, once they file this with the court, and even though the court was closed, so specifically talking about the Magistrate Court of Fulton County, even though that court was closed from March 14th until today, landlords can still file their dispossessory affidavits online. So a dispossessory affidavit may have been filed online against you, and it may not have been served. So you should receive some information about service soon if you have not been served. But if you're worried that you possibly have a dispossessory filed against you, I'd encourage you to go to the county's website, the Magistrate Court's website, and type in your name to see if anything pops up. So as I mentioned, when the dispossessory affidavit is filed by your landlord, they must serve the dispossessory affidavit. Now, I from a review of my records, I've seen some dispossessory affidavits served through private process servers, and those are private individuals who are served dispossessory warrants. But a lot of dispossessory warrants, I'm seeing that they have not been served. So if you have not been served with a dispossessory warrant, then that means you just don't have notice that an eviction was actually filed against you, unless your landlord told you otherwise. And there are three common methods of service. There's personal delivery, so that's handed it to you personally. Delivery to a competent adult, so someone in your household. An adult, though, it can't be your son or your child under 18. They must be an adult. and a competent adult. And there's also something we call tack and mail service. And this is the most common form of service that I've seen, where the private process server or the sheriff will just tack the dispossessory affidavit onto your door, and that counts as service. One key thing about tack and mail service is that if you were served by tack and mail and you did not answer the dispossessory action, then a money judgment cannot be awarded against you. Because it's a different types of service that, typically you aren't allowed to serve someone through tack and mail. Is just this exception in the dispossessory context. So they don't want to penalize you if you were never received that tack and mail service. So after you're served, that's when the answer period usually begins. But I do want to note that as of right now, if you were a dispossessory action was filed against you from March 14th to today, you weren't required to file an answer during that time. The Supreme Court issued an emergency order on March 14th, 2020, and they issued an amended order, I believe in early April, that just clarified that your answer period, for the most part, and I know this is true for Fulton County Court, wouldn't start until 7 days after the court reopens. And we're expecting the court and the emergency order is going to be lifted on May 14th. And so thus on May 14th, that's when your 7-day answer period is going to start. So typically, if you don't answer within 7 days, a default judgment could be entered against you. But because of this emergency order, that's not the case, and you're going to have additional time to answer. So the next part I'm going to go through is just how to answer this dispossessory warrant. I know a lot of people don't want to go to the courthouse, and you may not have to. You may find it more convenient to answer online. So this is specifically talking about the Fulton County Magistrate Court and the Fulton County process for answering. There may be exceptions or a different process for Gwinnett County or DeKalb County or Clayton County. So you'll need to go to that county's website to see if they have an online system available for you to answer online. But in Fulton County, there's the website, or you can just go to Google and type in Magistrate Court Fulton County dispossessory or Magistrate Court Fulton County eviction, and you should come to this website. This website was put together by the Magistrate Court, and it kind of explains what the dispossessory process is and how to answer. I don't know if you can see my my little arrow, but you can see towards the bottom of this website, there's the dispossessory answer form, and that's a PDF. So what you can do is you can print out that PDF form and fill out that form, and then take that form down to the Fulton County Magistrate Court or whatever magistrate court you're filing your answer in. But in Fulton County, at least, they also have access to the Magistrate Court's guides and guide and file system. And this is through a system called Odyssey, so you can e-file your answer. I do want to note that I did try to test it on how to e-file if you're just, a tenant and you're not a lawyer, basically. So I created a username and password, and I believe to e-file is going to charge you $7 for the envelope fee, regardless. So please be prepared to pay $7 in the e-file system if you file a dispossessory online. Here's the process. So once you click this button, access to Magistrate Court's guides and file system, if you just click that hyperlink there, it's going to take you to this website to start the legal process. And this is the guide and file interview system for Fulton County filing of dispossessories. So you'll click on start the legal process, and then you'll go down to Magistrate Court dispossessory answer. When you click on that, it's going to pop up explaining to you what this is, how the court isn't giving you legal advice. They're just helping you get through this process by walking you through the questions that need to be answered in order to file your answer to the dispossessory affidavit. So once you click continue, they're going to ask you to look up your case. And when you look up your case, you type in the county, and then you're going to type in the case number and verify, the verify button. And when you type in your case number and you type in verify, information should come up with your landlord's name and your name. And then what you want to do is click this is correct if it's correct. If it's not correct, then of course you click this is not correct. And at the bottom it asks were you able to verify your case number. And this just helps with the system. It's going to make it easier as you go through this guide and file system to file your answer. So after you get to that point, basically you're just going to be completing different steps. The steps are going to include saying whether or not you have any defenses, or saying if you have any counterclaims. It's also going to ask you to put in certain information like your landlord's address. You should be able to find this on the dispossessory affidavit that was filed against you. It's going to be on the magistrate court website if you don't have the hard copy on hand. And so there's going to be questions that you have to answer. Right here, I'm just showing you some example of some defenses that you can use in filing your answer. Because there are some defenses, even though failure to pay rent might not be a defense. If you try to pay, or if you have the money now and you can pay during your 7-day answer period, that's called the tender defense, which means that you have the money to pay, you're willing to pay, and so your defense is that you should be allowed to stay because you have everything to catch you back up, to reinstate your rent. Another defense may be that the landlord didn't properly demand possession. So that goes back to our step 1. They have to make proper demand of possession. And if they don't, then you have a defense that you were never given notice that the landlord was filing this dispossessory affidavit. Another defense that might come up if there is no landlord-tenant relationship, and this is kind of a special defense. It arises in the context it can arise in the context if you're in a rent-to-own agreement, or if you're in some kind of other agreement that allows you to eventually take ownership of a property. Or it could arise if the person who filed the eviction against you is really not your landlord. You don't really know who they are, or you may know who they are, but you know for a fact they're not your landlord, and you want to say that. Another thing that might come up is retaliation. So if a landlord has failed to make repairs on your property, on your rental unit, and you report them to code enforcement, and that is the reason why they're kicking you out, then that's a retaliation claim. Not only is it a defense to a dispossessory, but you can also get a money judgment if your landlord was to do that. Examples of counterclaims are the landlord's failure to repair conditions issues. And I see this a lot, and I hear this a lot from my clients, but I also see that a lot of people don't make these counterclaims even though they have conditions issues. So if your AC hasn't been working since March, that is a counterclaim. That is a condition issue that your landlord failed to repair. Now, you got to make sure you give your landlord notice of these issues so they're aware of it, but text messages and emails are sufficient for this counterclaim for those purposes. And also a counterclaim is if your personal property was damaged due to conditions on the property. So say if the property flooded and all your things were destroyed, or if there's a severe mold issue that got all over your personal items, you may be able to recoup those funds and that money through the counterclaim process. And it's important that if you have counterclaims and if you have defenses, make sure you include those in your answer, because if you don't, the judge is just going to assume that this is a straightforward landlord-tenant case. And especially if it's a failure to pay issue, it's likely your landlord is going to be granted what we call a writ of possession. So after you file the answer with your defenses and your counterclaims, then there's the hearing. Now, we don't know when the hearing is going to take place because, as I mentioned earlier, the court is currently closed. The magistrate court is not hearing landlord-tenant matters. But as of today, we think that they're going to restart doing that on or around May 14th, and it may be pushed back later. And we also hear that they're going to start off with landlord-tenant cases that were already filed. So those that were filed like prior to the emergency order that took place on March 14th, and then they're going to get around to the other ones as soon as they can. And the courts are also dealing with this, how to logistically handle this COVID-19 situation. But whenever your hearing is scheduled, it's going to look sort of like the picture. You're going to have an opportunity to state whether you have any defenses, and you're also going to have an opportunity to go to what we call mediation with your landlord. And in mediation, at least in Fulton County Court, there are mediators available in the courtroom, and they will call you into the mediator's room. Both you and your landlord, and you all will try to work out an agreement that includes either you moving or you all working out an agreement for you to remain in the home. And if you can't work out an agreement, then you actually will have what we call a mini trial during the dispossessory hearing. And you can go and you can present evidence. You can do direct examination of witnesses. If you have any, you can do cross-examination, which means question the landlord about discrepancies in their statements. So you do have an opportunity for a mini hearing and a mini trial at that point. But what I see is that most cases are resolved in mediation. And because you have this extra time before the court is even reopened, it's best to try to reach out to your landlord. And if you all can come to an agreement before all of this takes place, I think that's just a far better way to get this done. So let's just say, you go to mediation, you and your landlord weren't able to resolve anything in mediation, and you have your trial, and the judge rules in favor of your landlord and says you have to move out of the property. What happens is the magistrate judge issues what we call a writ of possession. And a writ of possession is basically saying, hey, the landlord has the right to come and retake their property. And if you don't move out the property at a certain date, then that's what gives the sheriff authority to come and put your things out on the street. So you kind of want to avoid, if you are issued a writ of possession, it is my recommendation that you immediately try to find somewhere else to go. I know that's a hard situation right now for a lot of families, but we're going to get to resources that may be available later for you if that were to happen. But like I said, you want to try to resolve any issues if you can with your landlord before it even gets to this point. But you can also, if you totally disagree and you think the judge was wrong, you have the right to an appeal. So you can appeal to the state court or the superior court. I would advise everyone to appeal to the superior court rather than the state court. And if you do file that appeal, you must pay the full amount of your judgment into the registry of the court. So you have to be able to pay that, and you also must be able to pay all future rent into the registry of the court. If you don't think you can do this, then I wouldn't really recommend that you appeal a dispossessory. I'm going to turn it over to Lindsay now, and I'll come back later to talk about helpful resources that might be available to you. Thanks.
Thanks, Darius, for all that information. So I'm going to talk about two main subjects. I'm going to talk about extended stay hotels because that's an issue that we've seen come up with a lot of people during this time. And then I'm going to talk about protections that are available under the Federal CARES Act that Darius mentioned. So first, we at Legalaid have learned a lot in the past few months since this crisis began about how many folks in our community, including clients of ours, are are living in extended stays, not just temporarily staying there, not using it as a temporary residence, but actually using it as their home. And when the crisis hit in March, these were the first tenants we heard from, because many people pay rent daily or weekly. They were the first ones unable to pay their rent when they lost jobs or they had to stay home to take care of their kids. So when a person in an extended stay doesn't pay that rent, what we've seen is that management almost always threatens to force them to leave, with some exceptions. And sometimes that's within days of them not paying the rent, and sometimes it's within hours. And some of these actions can be illegal. So under Georgia law, an extended stay motel pays an innkeeper tax to the state from the first day someone lives there to the 90th day, so for 3 months. During those first 3 months, tenants may not have a right to that eviction process through the court, the process that Darius just described. But after the motel stops paying the tax, they stop being treated as an innkeeper. And at Atlanta Legalaid, we take the position that residents of extended stay motels who have lived there for 90 continuous days, even if they've changed rooms, have a right to the eviction process, meaning that the management has to file that dispossessory or eviction case against them and get an order from the judge before the tenant can be legally removed. And we're talking to local police about this issue, and we really want to hear from tenants. So if you are an extended stay resident and the management is threatening to put you out, number one, try calling the police first to explain that you're a resident, that you've lived there for 90 days if you have, and that you have a right to the eviction process. Then contact Atlanta Legalaid during business hours so we can assess your case and give you legal advice that's specific to your situation. Okay, so now I'm going to move on to the Federal CARES Act. The CARES Act that you all have probably heard something about is a federal law that was signed and became effective on March 27th of 2020. It contains a lot of provisions, most of which we won't address in this workshop. And as a side note, I would just say that I think it might be nice if, for people who were looking into unemployment benefits, if the Beltline maybe consider that in the future, because I think that's an issue that a lot of people have questions about, because unemployment benefits are a little different under the CARES Act than they are under normal circumstances. So I'm going to focus on the eviction moratorium for landlords and tenants. And then my colleague, Sarah Kelsey, will talk about the foreclosure moratorium for homeowners. The CARES Act states that certain landlords are not allowed to file an eviction for non-payment of rent from March 27th through July 25th of 2020. That's a total of 120 days. And during that time, the tenant does still owe the rent. And we'll talk about that a little bit later. But even though the tenant owes the rent, unlike normally, the tenant cannot be charged fees or fines related to non-payment of rent. So I think probably most people have seen in their leases, most landlords charge at least 10% late fees if a tenant is even 1 day late on their rent. If your landlord is covered by the CARES Act, then you cannot be charged those late fees or fines. So that's during the entire 120 days, and the landlord cannot file an eviction. So after those 120 days, if one of those landlords who's covered by the CARES Act wants to evict the tenant, they still need to give the tenant a 30-day notice to vacate before they even file the eviction case. So essentially what that means for all intents and purposes is that certain landlords, and again, we'll talk about who's covered in a second, but certain landlords will not be able to file an eviction for non-payment of rent until August 25th of 2020. And that's only if the landlord sends the 30-day notice the first day they can, which is right after the moratorium ends on July 26th. If the landlord waits 3 weeks to send the notice, they still have to give the tenant the full 30 days. So for some tenants, that may mean that their landlords can't file an eviction until sometime in September. During that time, the tenant does have the full 30 days to either try to get caught up on the rent or to leave voluntarily before the landlord has an opportunity to file the eviction. Now, I'll just sort of like make a side note for a second before we talk about who is covered, and just say that the moratorium does not apply to evictions for reasons other than non-payment of rent. So Darius talked about the various types of evictions that can be filed. Non-payment of rent is the most common one. We think that's what most landlords are going to be filing for under these circumstances. But if, let's say, the landlord is filing an eviction because they're claiming that their tenant violated the lease, for instance, having a pet, if the rules don't allow it, or maybe not leaving when their lease expired and everyone gave proper notice, that person can still be evicted during the moratorium. But be aware that if you know your landlord is using some bogus lease termination notice to try to evict a tenant, we've seen some notices that just aren't believable, that, for instance, the landlord is trying to evict because somebody left a bag of trash outside their door on one occasion. If the real issue is non-payment of rent, the landlord still should not be able to get an eviction order. If you think that might be the case, that is definitely the time that you want to talk to an attorney. So the main issue, and I think a lot of the questions that people had who signed up for this wanted to know who's covered by the CARES Act. And as I said before, only certain landlords are prohibited from filing an eviction for non-payment during this time. The law calls landlords of those properties, these are called covered properties under the law. So how to know if you're in a covered property? If you live in any property that's income-based, for instance, where you report your income to your landlord as a condition of living there, or maybe you pay rent based on your income, then it's very likely that you live in a property that's covered by the CARES Act. If you live in a tax credit property or a property that's under a HUD subsidy, you're covered by the CARES Act. If you have a Section 8 voucher, you're covered by the CARES Act. If you live in a property where another resident at the complex has a Section 8 voucher, even if you don't, you are very likely covered by the CARES Act. And on that last one, there's a little dispute on this point, but you should definitely contact Atlanta Legalaid if you fall into that category and your landlord files an eviction for non-payment. If your landlord has a FHA loan, which means that the house, the mortgage on the house is insured by the Federal Housing Administration, or the property is federally backed by Fannie Mae or Freddie Mac, then the property is covered by the CARES Act. And I'll say that many, but not all of the multifamily properties that are covered, meaning, and when I say multifamily, I'm meaning those properties where, it's an apartment complex where many families live under separate leases. Many of those multifamily properties that are covered can be found on a particular website. And Jen, if you can show that website on your screen, that would be great.
One second, let me pull it up. There we go. Can you see it?
Yes. So if you scroll down a little bit, there is a lookup tool on this website. The website can be found at nlihc.org. And what you can do is you can search by city or zip code, and that way you can see if your property is one of those multifamily properties that's covered. We realize not everyone may be able to do this. One of the things that Atlanta Legalaid is planning on doing, we cover the 5 metro counties, Gwinnett, Cobb, Fulton, Clayton, and DeKalb. And for those counties, we are going to aim to provide the courts with actually as full of a list as we can of all the multifamily properties, so that if you're a tenant and you haven't done this work prior to going to court, hopefully the court will already be aware of whether your property is covered. So that's for multifamily properties. If you live in a single family home as a renter, it's gonna be a little trickier, to be honest, to figure out whether your home is covered by the CARES Act. And again, it's gonna be up to whether your landlord has a federally backed mortgage. It's tough for tenants to figure out that information. So it's gonna be up to landlords to share that with the court. And so that takes me to the next point. What are courts going to do to ensure that landlords are not filing evictions in violations in violation of the CARES Act. So the first thing that the courts have already done is they've decided as of last week that they're going to require every landlord filing an eviction for non-payment of rent during this time. And this is every landlord throughout the state of Georgia, not just in the Atlanta area. Every landlord who's filing for non-payment of rent, and this goes back to March 27th when the CARES Act was signed, up until the end of the CARES Act, actually 30 days after, until August 25th, the landlord's going to have to file an affidavit, either when they file the dispossessory case, or if they've already filed that case, they're going to have to go back and supplement and file their affidavit before they can go on to the next step and get the eviction order. The affidavit is going to swear that they are not a covered property under the CARES Act. Without that affidavit, the landlord is not going to be able to go forward with the case, and the case against the tenant should be dismissed. And this affidavit is just like testifying under oath. So landlords are going to be legally required to tell the truth in the affidavit. And this is going to be for multifamily properties and for single family properties. It's all landlords filing for non-payment of rent. So if you're a tenant and you have an eviction filed against you, and let's say you want to be sure that the landlord was correct in the affidavit or was honest in the affidavit, you can use a process called a notice to produce to ask that your landlord bring certain documents to court proving that you don't live in a covered property. And within a week or so, we're going to have a sample of that form uploaded to georgialegalaid.org. And I believe Jen is going to provide that website in the follow-up email after the presentation in case you're not writing it down, so don't worry about that. georgialegalaid.org has a lot of different helpful information for tenants. We're trying to update it as much as we can every time something changes, which seems like it's almost every other day. But because tenants don't have access to the information that landlords have access to about whether their mortgage is federally backed, that's what the notice to produce helps them get from their landlords. So the landlord essentially has to show up to court with the documents that show whether they're covered or not. So what happens if your landlord files an eviction anyway? Again, if you live in a covered property and your landlord files that eviction for non-payment between March 27th and August 25th, you should make sure you answer the eviction. And I know Darius talked about there's certain types of cases where you may decide not to answer because you weren't personally served and you may want to avoid a judgment. Before you choose to take that step and not answer within your 7 days, please consult a lawyer and make sure that that's right for your situation. It's a very fact-specific question. In most cases, you're going to want to file the answer to the eviction and make sure you show up for your court date. Right now, court is not being scheduled because of the judicial emergency that Darius mentioned, but at some point there are going to be court dates. In advance of that court date, send your landlord the notice to produce so they come with the documents you need. And again, if they are a covered property, the case should be dismissed on the spot. Not just extended to the end of the moratorium, but actually dismissed. So what happens at the end of the moratorium? As I said before, tenants who live in covered properties still owe the rent, but they don't owe any late fees or extra charges from March 27th to July 25th. And the landlord can't charge those late fees until July 26th. So after the moratorium ends on July 25th, again, landlords must still give or send that 30-day notice to vacate before filing the eviction. So this buys people some time. So Jen, if you can show the CARES Act one-pager, that would be great. So here, this is just kind of a summary of the important things to know about eviction, the eviction moratorium under the CARES Act. We've covered the majority of this, but I just kind of wanted people to have this. I thought this sheet was pretty handy, one of my colleagues made. And so and I think Jen will send that out after the call. Yeah. So the reasons why all this might matter with the protections under the CARES Act, what are those? So just a couple of reasons why these CARES Act protections are so key. One, many tenants during this time are just trying to get caught up on the rent. A lot of people we know are waiting for unemployment benefits. Some people have heard that they're approved for benefits, but they haven't started receiving them yet. Some people know they're going to start working again or working out daycare for their kids so that they can go back to work. So for a lot of tenants, this time is going to be key for them to actually get caught up on their rent. So this is not just a boon to tenants during this time, it's really a boon to landlords too, because landlords don't want to have to evict all their tenants. They have to pay their mortgage, they have to pay their bills. So if tenants can just be given a little time, the hope is that a lot of people will just avoid the eviction entirely. The second thing is many landlords are going to want to work with their tenants instead of evicting, again, because they have this incentive to not kick out all their tenants during a time when it's going to be really hard probably to get new tenants. Also, a tenant who really can't get caught up by August 25th can just choose to leave before the landlord files the eviction. Under Georgia law, landlords are not allowed to file an eviction against tenants who are already gone from the property. And when I say gone, I mean, the tenant has truly left the apartment or the house, they've removed all their belongings, and they've turned in the keys. And it's a really good practice to also give your landlord notice and say, look, I'm out. If the landlord doesn't want to accept the keys, leave them in the house or mail them to the landlord. Now, those landlords, they can't file an eviction of the tenant because the eviction is to get possession of the apartment or the home back, and they already have that. Those landlords can still sue for the rent, or they can put the charge on somebody's credit, but at least the tenant avoids the eviction, which is really the number one thing that we find that makes it difficult for people to rent their next home, is that landlords see that they've been evicted and they have a hard time getting approved for the next place. And finally, why this is important is tenants who just need to buy themselves time and who live in these covered properties, realistically, they won't be evicted through the courts until no earlier than mid to late September. And that's because of how long the eviction process usually takes. So when Darius was describing the fact that your landlord will file the eviction, you're going to get served with it, you have the opportunity to file an answer, to go to court, and then even if you lose at court, you still have another 7 days before you have to be out. That whole process takes, probably at least a month. So for some tenants where they just need time to be able to find another place, this is going to give them that time. So Jen, can you show that eviction flow chart again? So under this flow chart, it sort of explains how the CARES Act basically prevents a number of evictions, but also because the judicial emergency is still in place, at least until right now it ends on May 13th, no one can be evicted right now. The city of Atlanta also has its own eviction moratorium that went into effect about 10 days before the CARES Act, I believe. And that moratorium ends currently on, I think, May 16th. So under both moratoriums, most people, or the judicial emergency and the city of Atlanta moratorium, most people can't get evicted. As Darius said, evictions are still being filed right now, but answers aren't due until the judicial emergency is lifted. One thing I wanted to mention about that is Darius is right that you get extra time after the judicial emergency ends, but keep in mind if your landlord filed an eviction against you and you were served before the judicial emergency went into place, you only have the amount of time left on your answer that you had the day that the judicial emergency went in. So if 4 days before the judicial emergency, you got served with your eviction, you have an extra 3 days after the emergency ends. So basically, May 14th is your day number 1. That's why we're really encouraging people to file their answers now, even though it may not be due until later, because you just don't know. We don't know whether the emergency is going to be extended, and if it is, exactly what the provisions are going to be. I think we'll know that probably in the next 24 to 48 hours. But it's important that you don't miss your answer deadline. So I just want to mention a couple of things that Atlanta Legalaid is doing in regards to the CARES Act, and then I'll turn it over to Sarah. One is, I mentioned, we're making lists of covered multifamily properties for each of our 5 metro counties. So courts and the public know most of the multifamily properties that are prevented from filing evictions. 2, we have a sample answer that's already up on georgialegalaid.org that a tenant can file if their landlord filed an eviction and they think the property is covered by the CARES Act. We also have that notice to produce that we're going to get on the website before the judicial emergency ends next week. And also, I didn't really talk about this, but courts are going to have to figure out this whole process of having eviction hearings right now. Under normal circumstances, people who might have been to court know that 80, 100 people might be packed into a single courtroom in a dispossessory case or calendar. That's probably not going to happen for a very long time for safety reasons. So the courts are going to have to figure out other ways to handle these cases. And one of those ways might be holding hearings virtually. We know that some people, especially clients of ours who are low income and may not have access to broadband internet, that might be impossible. Or for people to actually come into the courthouse, if they are immunosuppressed or have other medical reasons why they can't come related to COVID, then they may need to ask the court to do something different for them. If somebody has a disability and they need something different from the court during this time, they should file with the court a request for a reasonable accommodation of that disability. And I think we're going to have a sample form up on the georgialegalaid.org website for that as well. And finally, I would just mention that Atlanta Legal Aid has not been closed a single day other than the weekends, but I mean, work days, we have not been closed a single day since all this began. We're not seeing people in person, but we are advising and then sometimes representing tenants who call us for legal advice. Certainly, once the courts open, we're going to be representing a lot more tenants. And I would just say the main number for our Fulton County office is 404-524-5811. And you can also find our numbers for our different county offices on our website. Jen, I have a question here on the chat board. I don't know if we want to talk about it now or you want to save it to the end.
Sure. I think we do have one question if you want to go ahead and respond to that, and then Sarah can queue up her presentation and start talking about mortgages. So we have a question, and you can probably read it as well. But if you live in a covered property and are owing rent, can that show up on credit or be sued? If you were to
Yes, it can, because the tenant still owes the rent during this time. And actually, we had a question from a participant that's kind of related to this that came up that they raised when they were signing up. And they said that if a landlord is actually getting assistance, the kind of assistance that Sarah might be talking about, can they still charge their tenant rent? And yes, they can. There's nothing in the CARES Act that says that they cannot charge their tenant rent. They can't evict their tenant during that time, but the tenant does still owe the rent.
Great.
I think that's it for me. I'll pass it over to Sarah.
Great. And if anyone does have any questions for Lindsay or Darius while we're switching presenters, feel free to put those into the chat.
Okay, I'm gonna share my screen once I figure out how. Oh, here it is. Okay, so I'm gonna talk about mortgage protections, protections for homeowners right now. So I'm going to talk about protections that are available under the CARES Act, as well as protections for those of you whose mortgages are not covered by the CARES Act. I'm going to end by talking about scams that we expect to see an increase in, just very briefly about how to spot them and how to avoid them, both home theft scams and mortgage assistance scams. So everything I talk about in this slide, I'm going to go through quickly. Don't worry, I'm going to come back to it. So this is an overview of protections under the CARES Act for mortgages. So first of all, there have been a lot of questions about who is covered. It's anyone with a federally backed mortgage. So that is FHA, VA, and USDA loans, as well as Fannie Mae and Freddie Mac loans. There has been some confusion about the foreclosure moratorium. That foreclosure moratorium, which is a stop to foreclosure activity, only applies to federally backed mortgages. And also, I want to point out that that moratorium ends on May 17th, but that doesn't mean that on May 18th, everything goes up for sale. It just means that so during the moratorium, mortgage companies could not initiate sales for any foreclosure activity on these federally backed mortgages, and they also can't conduct sales that have already been initiated. So it's not clear to me exactly what would happen on May 18th. Things could go forward in the beginning of June, but basically that activity could restart. The biggest thing about the CARES Act protections is the forbearance, which is a temporary pause or reduction in mortgage payments related to a temporary hardship. So anybody who has a federally backed mortgage who has experienced a financial hardship as a result of the coronavirus pandemic, they can request a forbearance from their mortgage company up to 180 days and then an additional 180-day extension. And then there are a variety of options after the forbearance ends. I saw we've gotten some questions about that, and I'll talk more about that. So some people have said, do I have to pay that whole amount at the end? That is an option, but depending on your circumstances and your mortgage and if you were behind or not before, there are various options. So first of all, one of the questions that we get a lot is, how do I even know if my mortgage is covered by CARES? My husband didn't know if we have one, a federally backed loan or not, and I'll talk about how you can find that out. So first of all, you can look at your mortgage statement. Sometimes it's on your mortgage statement, especially FHA mortgages. You can call your mortgage company and ask them. They will definitely know. For FHA loans, if you have access to your original mortgage documents, they're recorded in the deed records, but I know that not everyone can get to those. There is an FHA case on the security deed. Is the things you would have signed at your closing. It's like a big, long contract. And on the very first page, usually on the top right in a box, is the FHA case number. Sometimes it's on the left-hand side. And then for Fannie Mae and Freddie Mac, there are websites you can go to, and this will be recorded, but if you don't get a chance to write down these websites, I just Google Fannie Mae loan lookup or Freddie Mac loan lookup, and the right thing comes up. Both of them have forms that look like this. This is Fannie Mae's. So when you go to that website, you'll type in your information and click get results, and it'll either say match found or no match found. What I want to stress is that if there's more than one person in your house who may be on the mortgage, try all of their names, because sometimes only one person signed the promissory note, even if both people signed the security deed or other documents at closing. And sometimes it might say no match found, but if you put a different person's name in, it will come up. And then I didn't do a screenshot for Freddie Mac because it basically looks the same, but there's this website you can go to, and the same thing, you fill out a form, it tells you whether or not your mortgage is owned by Freddie Mac. Okay, so I talked about this briefly, but I'll talk a little bit more about what is a forbearance. This is the main protection that's available for people who cannot make their mortgage payments because of loss of income or any other reason they were affected by COVID-19. It's a temporary pause or reduction in payments, and an important thing is that this is available even if you were already behind on your mortgage. I heard somebody from, I think it was Fannie Mae, saying that you could be years behind if you're still in your home and they haven't foreclosed. You can apply for a forbearance, and if you've been affected by the pandemic. It just changes what options are available at the end of the forbearance. There are no late fees or penalties during the forbearance. However, interest still accrues. So that's the difference between just not paying and them not being able to foreclose. If you have a forbearance, they're not going to charge you any late fees. Now, this is the big thing, is that the forbearance must be repaid at the end of the forbearance period. So for, let's say it's a 6-month forbearance, you don't have to pay for 6 months, but at month 7, you have to start paying again. So there's a misconception that it's forgiveness, and that's not the case. It's also not a deferral, which is where the payments are due like later, like at the end. So when you get the, if you don't need the forbearance, I would say don't ask for it. Like some people thought it was forgiveness and tried to get one, but you will have to make those payments again. Okay, so how do you get a forbearance? You contact your mortgage company. This is important because some people who have done loss mitigation, which is where you're trying to avoid falling further behind your mortgage, are familiar with the mortgage company asking for lots and lots of documents. But in this case, they can't do that. All you do is you call, you say, yes, I affirm that I was affected by the COVID-19 pandemic. I have a temporary financial hardship and I'm requesting a forbearance, and that's it. So first of all, you can do this over the phone. However, some people have experienced the mortgage company's hold times are really long because they're getting so many calls. You can also go on the website. So a lot of mortgage companies in response started making specific CARES Act forbearance request forms available on their website. What you can also do is mail or fax a written request to your mortgage company, just saying, I've been affected and I'm requesting a CARES Act forbearance. Once you get an approval letter from the mortgage company, make sure you save that letter where you keep your important papers. And then the big question I get is what happens after the forbearance? Like I said, that money typically is due, all of it, at the end of the forbearance period. However, if you can't, contact your mortgage company before the forbearance ends because there are other options. So first of all, and I'll say that these options are available with a forbearance that someone could have gotten before the CARES Act. Outside of the CARES Act, you can contact your mortgage company about these kinds of things. So a repayment plan is the first one. This is where you are paying your regular mortgage payment and then part of that past due forbearance amount over time without additional fees. So this is a written agreement between your mortgage company. For example, if you had 6 months of payments that were due, you might make double payments for 6 months, or you might pay some partial amount until that past due amount is paid off, and then you go back to paying your regular payment amount. Another thing is a loan modification. So these are generally available outside of CARES Act, outside of federally backed mortgages, but basically this is a change to the terms of your mortgage agreement. Sometimes it's confused with a refinance because you sign extra loan paperwork and it extends the term of the mortgage sometimes, but it's not. It's still the same mortgage. It's just changing some of the terms of your contract with them. I won't get into too much detail about the specific modification options that are available under the CARES Act because they change based on whether it's a Fannie Mae or Freddie Mac or FHA loan. But some of them involve, possibly moving the payments to the end of your loan term. So maybe if you had a 6-month forbearance, your mortgage is extended by 6 months, and at month 7, you just start paying your regular payments. You just pay for longer on your mortgage. These are available. It's different depending what kind of mortgage you have and also how far behind you were before you got the forbearance. Okay, so some people are saying, well, I don't have a federally backed mortgage. What do I do? So loss mitigation is still available with most mortgages. If it's not federally backed, it's just whatever the private company that services your mortgage, whatever option they have. And this can include a forbearance, a temporary pause or reduction in payments, or a repayment plan to catch up on any past due amount, and also most commonly a loan modification. So what these will do is get you current on the loan and also reduce the payments. And they can do this by changing the interest rate. Most commonly, they extend the loan term for a new 30 or 40 years. And sometimes they involve forgiveness or a larger sum that's due at the end of the loan. There's a variety of options. The other thing I want to talk about is foreclosure sales for people whose mortgages are not covered by the CARES Act. So some companies have voluntarily canceled or postponed foreclosure sales, even if they aren't required to by the CARES Act. So if you want to know if that's what happened with your mortgage, call the mortgage company to find out. The important thing is if you were already in foreclosure, if you received that foreclosure letter from a foreclosure attorney, you want to contact that attorney's office, not necessarily your mortgage company. You want to call that attorney's office to find out if the sale is still happening. And if they confirm the sale has been canceled or postponed, ask to get that confirmation in writing. Even an email is fine. You want to have that confirmation in writing. So last, I'm going to talk about avoiding scams. Like I said before, these are both mortgage assistance scams where people charge money and say, I'm going to help you with your mortgage, and sometimes or very often don't help at all. And also where home theft scams, as I call them, where people are tricked into basically signing over their home to someone. So common features of mortgage-related scams. Charging money for help. One thing I didn't mention before is with any of this loss mitigation, any time you need help with your mortgage, you can contact HUD certified housing counsel. Excuse me, let me say that again. HUD certified housing counseling agencies, and I'll have that information at the end. You can get, you can get free help. They'll use aggressive tactics. So I get a lot of people asking, how do I stop the phone calls? They might call you, they might send mailers, especially if someone's home is listed for foreclosure, because that's advertised in the legal newspapers, so they have access to the name, address, things like that. Emails, text messages, even going door to door and sometimes refusing to leave. And they'll move quickly. They'll say things like, this is a limited time offer, you have to sign up now or you're gonna lose your chance. And they'll also, once it gets time to signing the documents, kind of rush people through and not give them a chance to read or ask questions, and discourage people from actually reading or getting assistance with reading and understanding the documents. They might guarantee results like, I can get a loan modification for 100% of my Bank of America clients. This just isn't true. This is a lie. This is a red flag. They'll discourage people from talking to trusted advisors, friends, or their mortgage company. They might say, oh, don't worry, we're taking care of it. Don't talk to them. This is so you don't know that they're lying, that they're either, trying to take your house, or in the case of a lot of mortgage assistance scams, they're taking the money and then they're doing absolutely nothing. They're taking money people could have used to stay out of foreclosure and not submitting a loan application, not negotiating with the mortgage company, not doing anything at all. They might also pretend to be affiliated with the mortgage company or with a government or a nonprofit agency. Like they might say they're from the Federal Housing Administration. Or what we've seen is people somehow find out how to contact someone and say, I see you're in foreclosure. I'm from the mortgage company. I'm from Wells Fargo or Bank of America or whatever. You just send $5,000 or however much money to me at this method, and I'll stop the foreclosure sale. And it's a total lie. They've basically just stolen the money, and now the person is even further behind on being able to get out of foreclosure. Unfortunately, what we see sometimes is that someone says, I'm going to help you. I'm going to lend you the money and help you catch up on your mortgage and stay out of foreclosure. And they'll include in the loan papers a quitclaim deed. So somebody thinks that they're just signing, a contract that this person's agreeing to help them. They've actually just signed over their house to the scammer, sometimes for absolutely nothing or for, some small amount of money, but either way, not an amount you would sell your house for. And then finally, there are foreclosure rescue scams where people know that they're signing their house over to the false savior, but what is actually, they're then going to rent their house back from the person. I'm sorry, let me say that again. They're going to rent their house from the person with this plan that they can buy the house back over time. But usually this is done, the rent could be high, that they can only buy it back at some high premium. These are contracts that are designed to fail because the person doesn't really want to help. They're trying to get a house for way less than the cost of a house so that they can either rent it or flip it and sell it and then make a huge profit. So Just say no to these things. If it sounds too good to be true, or if someone's rushing you and trying not to let you read something, just say no. So don't sign any papers or anything electronically that you don't understand. I want to mention that too, is that sometimes contracts or things will be on an iPad or a phone. An electronic signature is still binding. So if it's small screen and you can't read it, don't sign that until you've read it and understood it and had a chance to go over it with a trusted advisor, such as an attorney. And don't pay for help, because you may be able to get free help from HUD certified housing counseling agencies or other nonprofits. So where to get help? You can go to the Atlanta Legal Aid Society. You can go to HUD certified housing counselors, and the website hud.gov/find a counselor is a directory of all of the HUD certified housing counselors where in your area. You can put in your zip code or just search the whole state if you want. These are counselors that are trained by the federal government to help people. And also, if you're targeted by scammers, the Federal Trade Commission wants to know. You can report scams to the FTC at ftc.gov, and they've also got a lot of helpful consumer information. That's it.
Okay. Well, thanks, Sarah. And on this last part, I'm just going to go over what resources are currently available. I know someone asked in the chat box about rental assistance programs. So some helpful resources and some helpful phone numbers, they're listed on the screen. Of course, there's AVLF, the organization I work for. We provide rental assistance to families in Fulton County, and we may be able to provide rental assistance also to families in Clayton County, but that kind of depends. But you're in Fulton County, definitely feel free to give us a call, especially if you're in one of our standing with our neighbor zones. Like I mentioned earlier, I'm in the West Side Swan Zone. So if you live, or if you have if you live in the Washington attendance zone, the Brown Middle School attendance zone, the Hollis Innovation Academy attendance zone, you may be eligible for rental assistance through our programs. But like I said, we extended that to all of Fulton County and maybe parts of Clayton County. Jen is going to share with you some resources of other programs like the United Way that I received from one of our partner organizations, Chris 180, and it has a comprehensive list of every rental assistance program available in Fulton County at this point. And it has some information about the other counties as well. But our organization, unlike Legalaid, we focus primarily on the city of Atlanta and Fulton County. And there's also, as you heard, there's Legalaid, and there's a Housing Justice League. So if you have a community of tenants and you all want to come together to create a tenant union, or you just want to organize your complex, I would encourage you to call the Housing Justice League. They also have an eviction manual that's on their website, which I think is pretty good at helping you understand the eviction, the dispossessory process, and the steps to take. You can also find educational resources on georgialegalaid.org. That is a website sponsored by Atlanta Legal Aid, and they have tons of videos and resources about how to file this dispossessory, counterclaims, defenses. Just an amazing asset. Tons of resources for you. And if you'd like to read that Landlord Tenant Handbook that was published by the state of Georgia, that website is also there. So you can go there if you want to know more about landlord tenant. I do want to say, going back to our rental assistance program, we do not help with homeowners at this time. We only help provide rental assistance for tenants. So if you're a homeowner, you may want to call Sarah Kelsey or one of those HUD certified housing counselors to see what resources are available. And the document Jen is going to send out, it also only relates to rental assistance for tenants and not homeowners. So I think at this point, we're going to get to the questions. And I know there is a question about the judicial order that someone said it was extended to June 12th. So does that mean you don't have to file an answer? So at this point, at least as of when we logged onto this call, we don't have the text of the judicial order. So we don't know to what extent it's going to extend any landlord tenant deadlines or any foreclosure deadlines or home ownership related deadlines. So at this point, the answer to your question is no, because we just don't know. But as Lindsay mentioned in her presentation, we might know within 24 to 48 hours as soon as that release. Lindsay, I don't know if you wanted to say something else on that point.
That's pretty much exactly what I was going to say, is that we just don't know. The press release from the Georgia Supreme Court said that the Chief Justice is going to specifically allow courts to have more restrictive policies. So if a court in a certain county wants to be more restrictive and just say they're not holding any hearings at all, they can do that. I'm not sure. That kind of indicates to me that the judicial order is not going to rule out all hearings. It just, in the press release, specifically talks about jury trials. We'll kind of see what happens.
And Lindsay, we just got
so there's
a question about.
Yeah, so there is rental assistance available for people living in extended stays, yes. The best thing to do is to contact the United Way number 211 that Terry Lee mentioned in the beginning. That covers all of Georgia, not just Fulton County. So folks living in Marietta, folks living in DeKalb, they can call that number. And the goal of 211 basically is to connect people with resources. So 211 doesn't provide the money, but they connect you with agencies that have funds. The CARES Act put a lot of funding out there for emergency money. Not all of that money has made its way to agencies yet, but some has. So I think as that money comes through, and I know the city got some of that they're going to be distributing to agencies as well, we're going to see, I think, more rental assistance available. And Rich actually asked a question about unemployment. I think somebody previously, before the presentation, had asked if you're not getting unemployment benefits yet, let's say you've been denied or you're just waiting for an answer, that does not impact whether you can be evicted or not. So it has no bearing on it. If you're living in a covered property, you're still protected by the moratorium. And if you're not living in a covered property, your landlord can file an eviction, and they'll just have to wait until the courts are actually scheduling hearings.
And I will be sending out a follow-up email that has all these numbers listed, a few attachments that we shared today, and the one that Darius is mentioning, so you all have it in one spot. I know a lot of the information was shared here tonight, but we will do that in a follow-up email afterwards. Are there any more questions at this time? Of course, if you have specific questions, we'd be happy to connect you with the presenters afterwards as well. So I'm not seeing any more questions. I do have just a few highlights from the presentation. I was going to do a 20-second wrap up, but there was so much great information shared tonight. I think it's going to be hard to do it in 20 seconds. Again, visit the atlstrong.org website for a comprehensive list of information, 211 for different community assistance, 311 for City of Atlanta questions or resources, and 911 if you believe you're being illegally evicted. If the courts reopen on May 14th, you will have 7 days to file your answer between March 14th and now. Include that defense and counterclaims. Rental assistance may be available to you to help avoid the eviction process, which we've mentioned, and I will share again at the end. Definitely contact any of the presenters if you have questions or need more information. Certain landlords are going to be covered under the CARES Act, both for rental and mortgage help. And we will provide different resources so you can see if you guys may be covered under that. I just have so many notes. There were so many great things, and I'll make sure to include those in my follow-up email so everyone has those. But just to wrap up, thank you all for your time tonight, and we hope that you all stay safe and healthy and can find the resources that you need during this time.